Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons have business to do before this court shall draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. Good morning. The first case for argument this morning on the calendar is case number 1003, People versus Smith.
Good morning, Your Honors. I submitted a stipulation to withdraw the first 2 points in the brief. I just left the argument on the calendar to make sure that that was received and accepted.
Yes, it was.
If that leaves a harsh and excessive, which I'm happy to answer questions on or be heard on, but I know that normally that is not a point for argument.
Hearing none, thank you.
Thank you.
Case 106 is People versus Brown.
Good morning, Your Honor.
Good morning.
May it please the court and Mr. Brown. I believe the indictment must be dismissed on the basis of legally insufficient proof that this was a qualifying order. The people had the obligation to prove beyond a reasonable doubt that a defendant, quote, would have understood that he was permitted to interpose objections or make an argument as to why an order of protection should not be imposed.
Counsel, if the order was entered on consent, does that make it an order that qualifies under the federal law?
No, Your Honor, I believe not, because the consent is only as good as the record that produces it. This court, on a regular basis, finds a much more elaborate record to be insufficient in cases where a defendant has waived his right to appeal a conviction, where there's an attorney present, the judge explains it all, and yet, because the explanation is not what it should be, this court finds it to be invalid.
But both parties were present in court, correct?
Mr. Brown was present in court, and someone, I'm not sure exactly who was present on behalf of...
The face of the order says both parties present in court.
Correct, correct. But Mr. Brown was not represented by counsel, and we do not know the nature of this.
How do you know that when you look at the CCs on Exhibit 7?
Because the only proof at trial here, I submit that the only proof at trial here was...
It's one thing to say you don't know.
Correct.
But it's another thing to get up here and tell me that you do know that he was not represented by counsel when I'm looking at the CCs, and the CCs indicate that counsel will serve with the order. And the case has been pending since almost a year before.
Correct.
March of 2015, whatever it was, 16, I think. So I get your argument, don't get me wrong, counsel.
Right,
I understand where you're, it's an interesting argument.
This is
but
the
it comes
first...
down to Exhibit 7, correct?
I mean, I submit that the prosecution has to prove the nature of the argument, and frankly, I do argue that even if there had been counsel present, in the absence of any evidence at all as to the proceeding in family court, we cannot presume or we cannot know whether counsel was permitted to make the argument. Generally speaking, obviously counsel is permitted to make whatever argument might come up, but certain arguments can be prohibited, and if that had been prohibited, then even counsel wouldn't be able to make the argument. Although
the issue you really want us to look at is Exhibit 7 sufficient evidence as a matter of law?
Well, is it to match what the language that I read from the Second Circuit? Absolutely, yes.
That's a little different case, right? Didn't that case arise out of a town justice court matter where it's a criminal proceeding? Here, in that situation, I would say, Counselor, that perhaps one could argue that, I think it's Bramer?
Yes, Bramer.
Right? In Bramer, it rises out of a criminal proceeding where you're at the, I mean, I used to be a town judge, so I recall how it worked. You're there typically off the record, and you don't want the criminal defendant to be saying a lot, to participate in the hearing. Here you have an Article 6 custodial proceeding where the order that was upon default has been changed to one that's upon consent, where both parties are present in court. So something happened in that court appearance in January of 17. I'm getting my years confused.
Right, right. Well, the other thing that I think we need to keep in mind, too, is this was not a new order. There was the other order that the trial court acknowledged was not a qualifying order because it was absent in the absence of the defendant.
It looks like what happened was that in the family court proceeding, the first order was issued without your client being present.
Correct.
It ordered him to stay away from the mother and his own children.
Correct.
Then about 9 months later, or several months later, it was changed to say you still have to stay away from the mother, but you can have no offensive contact with your children. It sounds like it was at his own request. But your point, I guess, is that these are things that people have to prove at trial, and they failed to prove them.
Absolutely, and they have to prove that he knew he had the right to object to any order of protection being issued at all. And I think Bramer is actually, it is different, but it's a stronger case because counsel generally knows that they can object to anything in the court of circuit.
But unless the transcript, when the order of protection was issued, what does the court have to do there, the issuing court, to make the order qualified? It would have to say, Mr. Defendant, Mr. Respondent, do you understand you have the right to be heard on this order of protection?
It's a minimal requirement. I mean, basically the court would have to not say the wrong thing in a lot of ways, or at least give the impression that it's, but the problem is, I think this is much like this court being asked to review a family court proceeding and determine that due process wasn't violated, and you don't get a transcript.
We understand. Thank you.
With regard to Batson, the people's counter-argument that I wanted to address was there essentially a hope that there was a gesture or facial expression or something that amounted to a reason to target this particular juror, but the trial prosecutor didn't say that at the time of asking the questions, didn't say that when challenged with regard to Batson, and therefore I think the pointed question for the juror, if the case isn't dismissed, I think it must be reversed on that basis.
Thank you, counsel.
Thank you.
Case 1007 is People versus McMurtry.
Your Honor, he is not in the list.
He's not in the waiting room online?
Nope.
All right, we will deem that submitted. Case 1008 is matter of Leonard P. Waiting for Miss Conley, I believe. Good morning, counsel. You may proceed.
Good morning, Your Honors. May it please the court. Caitlin Connolly for the appellant mother. Just a few comments on the evidence underpinning the abuse determination, Your Honors. The department's physician witnesses who examined the child approached this case with the assumption that he had been abused and evaluated the child only to the extent necessary to support the premise that they had begun with, that he had been abused. Although the parents' purported lack of an explanation for the child's injuries was the foundation for each physician's opinion, neither physician personally spoke to the mother. The child was born with a heart murmur, he had a difficult birth, and frequently sought medical treatment for his life. He had retinal hemorrhaging in one eye, and the child apparently had no external bruises or fracture. The child had been in the hospital just with a stomach issue just 2 days before the incident occurred. He admitted that the child's injuries were caused by an underlying natural condition. Critically, the record also shows that the mother wasn't with the child immediately prior to his hospitalization. For these reasons, the abuse findings as to the mother should be reversed as lacking a sound and substantial basis in the record. Unless the court has any questions.
Counsel, my recollection of the record is that there were two different doctors that didn't support your theory that you just espoused about this being a natural condition. That there were two doctors who basically said this was non-accidental injuries, and 0 doctors to support your position. Isn't that right? Isn't that the correct reading of the record? Or?
That's correct, Your Honor. My position is that the 2 doctors did not perform a thorough review of the child's medical records. They looked, for example, the ophthalmologist looked only at the eye, and neither doctor looked at any of the skeletal records or the birthing records.
Well, Counselor, they concede that point, that they did not review the records, but they did opine on the child's original birth condition, which I think is one of your arguments, correct? The amnio fluid or around the brain when the child was born.
Yes, the doctors denied that could be a cause.
Right, and they both testified within a reasonable degree of medical certainty that it was a shaken baby case. Without
Yes, Your Honor. Oh,
Go ahead.
I beg your pardon, I didn't mean to interrupt.
No, that's good. I had finished my question.
Okay. Your Honor, again, the point is that these physician witnesses came in believing this was abuse from the start. They did not carefully review the records. They also, one foundation for the opinion was that the mother or the parents offered no explanation, but neither physician ever spoke to my client, the mother. And this is important because these specialists might have seen something from the responses had they ever spoken to her.
Right, Counsel, look, I think you make some good points that there are legitimate questions, as we said in People versus Bailey, regarding shaking baby syndrome. It's based on speculation. There's some real questions with that. If your client were charged with a crime here, which is a much higher burden of proof, it might be a different story. There's a lower burden. As Justice Bannister indicated, there were two medical experts who opined that this was a result of being shaken, child, and your client had no expert. And your backup argument is that the lawyer should have obtained an expert, but as we've said in other cases, we just can't assume that there's an expert out there who would agree with your position. But we understand your arguments.
Thank you, Your Honor. Thank you.
Mr. Mannion.
Good morning, Your Honors. For the Department of Social Services, Benjamin E. Mannion. Unless there are any questions of the court this morning, the department will rest on its papers.
Thank you. Mr. Fox, you wish to be heard further?
No, Your Honor. May it please the court, Russell Fox representing the P children. Converted that this child's injuries, multiple injuries, or rather hemorrhages, could only have been caused by non-accidental trauma, and that child was in the exclusive care of these respondents during the relevant periods. If the court has any further questions, we would rest on our papers.
Thank you. Case number 1011 is a matter of Dorica S. 1011. Mr. Pajak is joining us virtually.
Okay, here we are.
You may commence.
Thank you, Your Honors. Dave Pajak for the mother of Bassimi. I'd like to begin by addressing what appears at page 11 and 12 of Russ Fox's brief on behalf of Dorica. It focuses on the CAC, that is the Child Advocacy Center interview with the child. During the interview, the child says, Leopold was keeping me, that's the stepfather, was keeping me from going to bed, and all mom said was, go to bed. She also says during the interview, I told mom this in October, and all she told me was to pretend to go to sleep. Now, we still don't know what exactly Dorica said to Bassimi. We don't know whether, and we can't presume that she told mom about the sexual penetration. We can't presume that she told mom that dad attempted or stepdad attempted for her to perform oral sex on him. Now, Bassimi says there was a conversation with Dorica on or about Sarah's birthday, the day he was born, actually, which was August 8th of 2019. She says at that time, Dorica disclosed that Leopold had been touching her. She felt uncomfortable about it. So it's not that Bassimi took no action. She, in fact, told Leopold, instructed him to stay away from the children, don't be near the children alone. And as a matter of fact, you're not sleeping here at night anymore.
So, Counselor, is that, I mean, there's no doubt here that prior to the DSS investigation, the child reported to her mother that there was contact, correct?
That's what I'm talking about here.
The question is when. But other than the mother's response that I told him to stay out of the bedroom, mom didn't do anything else, did she?
Well, she told him not to sleep there anymore, and he was out of the picture after that.
But he was still in the picture because she still had a relationship with the unborn, well, the child that was born even after this incident.
Right, but that child was born in April of 2021, which proves only that Bassimi and Leopold, the stepfather, had conjugal relations as recently as July of 2019, before mom had this conversation with Dorica, before there were any disclosures at all. That's all that proves. It doesn't prove that they had an ongoing relationship, although I'm sure he showed up a couple of times. There's no indication that he had access to the children. There's no indication that he abused any of the children after Dorica told him, "You're not sleeping here anymore."
Would you agree that if the child told the mother in August 2019 that it wasn't just touching on the shoulders as the mother believed, but it was sexual contact,
Then squarely, yes. Then she would be liable under 1012. Absolutely.
And there was yet another child that she had with the stepfather beyond the one that was conceived in July. I get it, but she's not charged. I mean, that was in violation of order of protection, was it not? It was, that child was conceived when there was an order of protection in effect?
I thought the youngest child was, what is it, Catherine?
Elizabeth.
Yeah, there's another one that occurred after the order of protection. But in any event, that's not charged here, it's not relevant, but it is telling. Anything further?
No, I did not realize that Leopold was the father of any child born after Elizabeth. I'm sorry. I thought Elizabeth was the youngest. I apologize for that. So, no, I have nothing for you.
Okay, thank you. Mr. Mannion?
Your Honors, again, on behalf of the Department, Benjamin E. Mannion, pending any questions, the Department rests on its papers. Thank you.
Thank you. We have 4 AFCs. Mr. Muldoon is here. If you could go first, please.
Your Honor, may it please the court, just listening to Mr. Pajak's recitation of the chronology of this,
Which child do you represent?
Muna Zero, it's a girl,
Okay.
now 3 years old.
Now,
Thank
just
you.
before
I'm
you get
sorry.
started, all the children's positions are consistent? In other words, we have 4 AFCs, but all the children's positions and counsel's positions are consistent with each other?
Yes, Your Honor.
Okay, thank you.
May it please the court, Gary Muldoon on behalf of Muna Zero. I should note that that in addition to this appeal by the mother, there is also pending an appeal by the male, Leopold, that should be argued early next year. The facts of this case, I think, are straightforward. There was a disclosure.
Was the stepfather charged criminally?
As best I know, Your Honor, there's nothing in the record that would disclose that. And I am unaware of anything, even outside the record, that discloses that there was criminal charges filed against the father. One of the salient, what Mr. Pajak stated, and I'm not sure if I caught exactly what he was saying, was that this incident occurred approximately August of 2019, and that there would have been no sexual contact after, because the the youngest child, Elizabeth, was born in 2021. She was born in April of 2021. It's actually a year and a half later. So maybe I misheard, and if I did, I apologize to the court for. But there certainly would have been sexual contact between the other respondent, in this case, Leopold. Yes.
I just want to refocus you a second, okay? You told us that all the law guardians, attorney for the children have the same position, but you haven't told us what that is yet. You start off by telling us generally.
I'm sorry. My position is that the family court order should be affirmed. And in part, my position is based on the absence of either of the respondents in the court below, the mother or the father, stepfather, having taken the stand or really contested this. There should be a negative inference taken from both of their failures to testify, which is based on the evidence that was presented, as well as the application of the appropriate adverse inference which Judge Brinkworth applied. There should be a finding of neglect or abuse against the mother in this case.
As I understand Mr. Pajak's argument, he said the child disclosed to the teacher and then to the authorities in October of 2019, at the end of the month there. The allegation is that the child told the mother something was going on in August of 2019, and the mother failed to protect the child thereafter. According to Mr. Pajak, that communication from August 2019, the mother interpreted that to be just some touching of the shoulders, no sexual content, and that, but his larger point is that after that disclosure to the mother and to the teacher and to DSS, there was no more sexual abuse. So therefore, the mother didn't fail to protect the child. That's the way I understand his brief and his argument. Do you wish to be heard on that?
I have no further comment on that. I would invite the other AFCs to offer their viewpoint on that particular issue. I'm not sure that that was really elucidated at the trial level.
Right, and we don't need actual proof of physical, that the condition that there was sexual abuse, as long as there's imminent danger thereof, right?
Certainly, yes.
So,
Correct.
There's that issue. All right, thank you.
Thank you. Oh, and just as under, I have met the child since then. The child is living with the mother and with her siblings in Buffalo. It appears to be doing well. And I should note that as part of my representation, with the 3-year-old child, I am substituting judgment.
All right, thank you.
Thank you.
Ms. Lorenz, do you wish to be heard further?
Yes, Judge, just briefly, good morning. May it please the court, Jennifer Lorenz, attorney for the children, Jibu and Salama. I agree with my co-AFC that the trial court's determination should be affirmed. I just want to briefly comment on Your Honor's question. The record establishes that Dorica disclosed the allegations of sex abuse to the mother in August. I think the case law is clear that simply telling the stepfather not to be around her or not to sleep over is not enough, and her failure to remove him from the residence does support the finding of abuse and a derivative abuse for my clients. So unless the court has any questions, I will rest on my brief.
Thank you. Ms. Connell?
Thank you. May it please the court, I represent Elizabeth, who is absolutely derivatively abused. The parents were arraigned in November of 2019 on abuse charges, and my client was born, I believe, 15 months later. So the mother was well aware of, if she was not aware, which I don't believe is true, I believe she was aware of what was happening with Dorica and chose to ignore it, but she was definitely aware of it when my client was conceived and when my client was born, and I can't think of a more clear-cut case of derivative abuse than that.
Because, Counselor, the point you're making is that mother continued a relationship with stepfather even after the DSS investigation was well underway.
More than the investigation, Your Honor, she was arraigned.
She was
in court, and she had knowledge of all of the charges.
Good.
Thank you, Ms.
And I
Connell.
would rest on my brief for anything further. Thank you.
Case number 1016 is a matter of Amelia D. Oh, I'm sorry, Mr. Fox, yes. I skipped over you there. Do you wish to be heard? He left. My apologies, Mr. Fox. His position is consistent with the other AFCs, and he did file a brief, so we will review that carefully. 1016. Thank you. Mr. Greenberg, good morning.
Thank you, Your Honor. I'm representing Sean D. in his appeal from the termination of parental rights judgment. He's actually appealing from the lifting of a suspended judgment. So he already admitted that he had permanently neglected Amelia, and he had entered into the contract to services. So the only issue that is before this court is whether the suspended judgment should have been lifted, or should he have given additional time to complete the program. And that actually does put me at a certain disadvantage because he did testify below. And he did admit that he didn't really do any of these programs that he was supposed to be doing. And his trial counsel, Todd Potter, basically argued in his closing that he should just be given more additional time to finish the program. And I think the argument was that, at least as I construed it, is that the reason why he didn't complete the program, Your Honor, is because there were circumstances beyond his control. He became incarcerated, he lost his job, he couldn't continue with the mental health treatment because Amelia's maternal grandmother was in the same program that he was. And it
Well,
wasn't.
I mean, the problem, of course, is that he didn't even get evaluated, which was the first step for mental health,
Yes.
for substance abuse. It happened well before he was incarcerated in September of that year. That makes it, look, everyone wants to try to give the guy a break, any parent a break. He did get a break with the first suspended judgment. You're asking that he be given another break with another suspended judgment, and we can take a look at that, but his compliance, it wasn't like he was close to complying with the first one.
Well, that's what he admitted to at the trial. He would also, I would also point out, is that he never really had any kind of meaningful visitation with Amelia. It was always virtual. She was always eating breakfast or being put on a bus to go to school, so it was also dependent on internet connections, which aren't always the best. So I'd ask you to look at that as well.
Thank you, Mr. Greenberg.
You're welcome.
Mr. Mannion, do you wish to be heard?
Briefly, Your Honor. Your Honor, I would just point out, in addition to what was put in the brief, that the analysis at this point is best interest of the child. I would also point out that on the record, as was previously indicated, the respondent in this case has had little to no meaningful contact with the child. Therefore, I would ask this court to affirm the finding of the trial court. Thank you very much.
Thank you. Case 1017 is Herneckar versus Wiggins, 1017.
Yes, may it please the court? I only have a couple
Counsel,
of quick
if you just
remarks.
wait, just
Oh,
wait
I'm
for counsel
sorry.
to come up.
I'm sorry.
No problem. And we have Ms. Gray we're waiting for virtually, and she is now with us, so you may proceed.
Okay, I just have a couple of quick points. I'm not going to rehash my brief. I just want to emphasize this case is 2.5 years old. That's a lot of counseling. It's a lot of supervised visitation. So I would just ask the court, when making up their mind about what's appropriate, that's a lot of counseling to address issues with. And she had a lot of counseling during the trial itself. So that goes to visitation and physical custody.
Has she moved to modify?
I can't hear you.
Has she moved to modify this order? It sounds
Yeah,
like you're saying
she-
she's had a lot of visitation and therapeutic visitation and so forth, counseling, and
That's
now
her
she's
next-
ready to
that's her
move.
next step.
Now she's moving on, she wants to move on to the next step.
Right.
But that would seem to be something that she would have to ask for at the trial level, right?
Probably. You could make a determination and send it back to Ontario court. If you do that.
Okay.
And also, I freely, I'm sorry.
No, I just said I understand, yeah, it's a good
I
point.
freely admit my client, the couple of months before this action started, sent crazy harassing emails, out of bounds. But it's a lot of counseling after that.
I understand. Thank you, counsel. Ms. Pinault.
Thank you, Judge. May it please the court and counsel. I believe the trial court decision was well thought out. There was a tremendous amount of evidence.
This was a 6-day evidentiary hearing, correct?
Yes, with recordings, the mom testified. It was really kind of extraordinary, her lack of insight and the effect on the child, her lack of understanding of that. I believe the decision was correct, and mom has filed a modification petition, and at this point, it's set for trial at the end of January. There has been a slight modification of the order that mom is allowed to participate, well, attend public events for the child, but even now there's been some difficulties with that. And the appellant put in her original brief letters that were not before the trial court And if you look at the letter, unsworn letter, even from the therapeutic counselor, this child still struggles with the mom in a therapeutic setting, that mom just doesn't get it. Mom has, I think she means well. She loves her daughter, but she doesn't get what she's doing to her daughter. She's not letting this kid be a kid and not being a mom for her. Unless you have any other questions, I'd rest on my papers.
Thank you. Ms. Gray?
Thank you, Your Honors. I've represented this young lady throughout all of the lower court proceedings and throughout this appeal, and I'm still in touch with her on a regular basis. There is a pending Monroe County Family Court case. Both parties have moved to Monroe County. They're no longer in Ontario, but I have agreed to continue to serve my client. I think that with all due respect to counsel, he's totally wrong in his brief by alleging that the enmeshment of the child occurred due to the litigation that was filed. Absolutely not. This enmeshment and parentification of my client started years before this matter was brought to court. She's still counseling with Dr. Corin. She's doing remarkably well. She's an honor student. She's in dance. And I have seen a 180-degree change in my client's behavior and functioning since this matter was first brought to Ontario County Court.
How's she doing with the therapeutic visits with the mother? Are those ongoing?
They're ongoing. They occur every other week. She has told me, and we're attempting to settle the Monroe County case, that she would be okay spending a couple hours here and there unsupervised with her mom. She's much older than she was when this all first started, and we're trying to work toward that. But for the relief requested in this appeal, and coincidentally, I mean, I have asked the trial counsel for mom to withdraw the appeal and just move forward on the modification, and she's refused. But to throw out the lower court order or to somehow send it back for another 6-day or more hearing, I think is certainly not in my client's best interest or in the interest of justice. If there are no other questions, I would rest on my brief.
Thank you, Counselor.
Thank you.
Case number 1018
Thank you.
is the next case on the docket, matter of Latoria B, 1018. We have Ms. Chadwick with us virtually, waiting for two others, waiting for the AFC. There we go. Ms. Chadwick, you may proceed.
Thank you, Your Honor. May it please the court, Amy Chadwick for the respondent father. The matter before us is a termination of parental rights. It's our position that the court erred in granting summary judgment on the fact-finding portion of this TPR.
Okay,
Granted.
Counsel, let me stop you. Did the court grant summary judgment? That's really not my reading of the record that they granted summary judgment.
Yes, the hearing began, and after the testimony of the first witness, the judge had discussion with the attorneys and said, I think I'm obligated to make a fact finding of severe abuse here as a matter of law.
Wasn't there an admission of severe abuse? In other words, why have the hearing when you have the admission? We're not even talking about the criminal conviction. But maybe I'm missing something, but both parents admitted to severe abuse.
The fact-finding order itself does say severe abuse. If you look at the actual colloquy from my client, it does not establish severe abuse.
Correct. That's right. And now look, and I happen to agree with you on that. It's not preserved, but be that as it may, I don't know why there was a hearing necessary in the first place. You're saying the court granted summary judgment, and it seems like that there was no need. It would be like if somebody pleads guilty to a crime, bringing in a jury. It's not necessary.
The court granted it under social services law 384B8D, which only applies to depraved indifference abuse or felony sex offenses. And if you look at the original order, the underlying fact-finding order, it does not specify depraved indifference abuse as the grounds for the finding of severe abuse. It actually doesn't specify any grounds at all. So this order terminating his parental rights and finding severe abuse says for the very first time that the finding is depraved indifference abuse.
Right, and look, I agree with you. There's no evidence that I've seen that either parent severely abused the child as severe abuse is defined. Serious physical injury, depraved indifference. This was corporal punishment. And corporal punishment standing alone is not severe abuse. There has to be serious injury and then the depraved element you talked about. But those are all matters that would be subject to a motion to vacate their admissions. Your clients admitted something that it doesn't look like they did, but it's still there unless and until it's vacated. But even assuming you get around that, and I know you say that their lawyers were ineffective for allowing them to, walking them into that admission, but we then have the fact that both parents were convicted, pled guilty to felonies that would qualify under 384B for termination of rights. Do we not? We have one pled to assault second, one pled to attempted assault second. So
Yeah.
what, even if you're right on the admission, there's two reasons to terminate the rights. One's the admission, one's the convictions. So what if the admissions were bad? We got the convictions.
True. However, the section that was used to grant summary judgment doesn't apply to subsection 3, which covers the assault second. Also, in addition, there needs to be a finding that reasonable efforts were made or that those were waived. And yes, here there is an order from this court saying that reasonable efforts are no longer required, but that order itself was based entirely on the original fact-finding order. I mean, the judge said himself in the decision, the actual admission wasn't enough to grant the motion that no reasonable efforts were required. The admission in criminal court wasn't enough because there was no admission to severe abuse, but it was granted anyway, just because this order was issued and it was never vacated. And it's really problematic. I mean, even the judge here, when you look at the argument on that motion to terminate reasonable efforts, the court itself is saying, I've looked at this, and what he admitted in family court is not what this order says. So it kind of just all snowballs. But to ultimately terminate his parental rights stemming from an order where he never admitted to severe abuse. And as you mentioned, the record itself.
Counsel, he did admit to severe abuse. He just didn't delineate what the acts were that added up to severe abuse. At the time he admitted to severe abuse, very clearly, was told by the court, you're admitting to severe abuse. There were criminal charges pending, and it was in your client's best interest not to have all of those acts delineated on the record and used against him in the criminal court. Okay, so there was a self-serving reason to do exactly what was done here, in my view.
Well, I understand, but I don't believe his admission. Yes, it was labeled as severe abuse, but the actual admission he made was just to excessive corporal punishment that caused injury.
The alternative to his admission would have been a full trial on all of these acts, which may have elucidated more than we have on this record. It was your client's decision to not let that occur or to prevent that from occurring because that affected his penal interests. Okay, that's what I can see going on here.
I think we also need to take into account his cognitive limitations. I mean, when you look at the day the admission was made, the court and the attorneys are discussing, are we also going to, talk about disposition? And they say, no. They're already having a hard enough time understanding, to get to this point.
Well, there is a lot going on here besides the family court issues. There's criminal issues, and there is a lot going on. I grant you that. And the court took it slow.
And if you actually look at the transcript from the day of the admission, you get to the end, and my client says, wait, did he just say severe abuse? So he understands, I'm admitting that I used excessive corporal punishment. I'm admitting that this caused injury. But he never
Right, that's
admits
a far cry from severe abuse, but
severe abuse.
what we
Yes.
talked about earlier was that these are all arguments probably better suited for a motion to vacate the admission. Because we don't know for sure what all the medical evidence was. It doesn't look like there's any depravity here which is required. It doesn't look like there's serious physical injury. It looks like this is corporal punishment and an assault third at best. But again, these are matters, your client didn't understand things. Those are matters better argued in a motion rather than before us.
I understand. And, in the interest of justice, if you have the power to do so, to send this back, by the time it got to me, the children are already gone, they're already taken. Given how obvious these errors were and the acknowledgement from the court that, he did not admit to severe abuse. It's really, to have his parental rights terminated based on that, it's a violation of his due process, and we would ask that the court reverse the findings.
All right, thank you. Mr. Banaszak?
Good morning, Your Honors. Peter Banaszak for the mother, Bianca B. I would ask Your Honors to consider perhaps the broader context that we're dealing with. And the U.S. Supreme Court has said when it comes to terminating a parent's parental rights, there are far fewer forms of state action that are either so severe or so irreversible. And I think given the gravity of this proceeding, it's reasonable to require a court to strictly comply with the statute that the legislature has said should govern these proceedings. And in this case, the lower court initially said there was no need for a fact-finding hearing because of the prior severe abuse adjudication. Now, I'm not challenging that prior severe abuse adjudication in the Article 10 context, but for purposes of the TPR, under 8D, summary judgment is permissible if there is a prior severe abuse finding under either 8A1 or 8A2. There are other forms of severe abuse, but it is only those two findings that warrant summary judgment, and neither of those findings was made by the lower court in the Article 10 context, nor were either of those things admitted to by the mother or frankly, the father. So I hear the court saying, we have this other basis for termination under 8A3, but our position is that the issue here is really one of procedural fairness. If the court wanted to grant summary judgment under 8A3, it should have said so before issuing its decision and given the parties an opportunity to contest the finding under that specific statutory subsection.
Counsel, let me interrupt you. Procedural fairness. The reason we have this admission is because the mother and father chose not to go forward with the fact-finding hearing. Caseworkers were ready to testify that there was bruising in and around the children's eyes, scarring on their foreheads, up and down their legs and around their spines, that they were hit with a belt and a back scratcher 4 times a week. And instead, your client admitted to severe abuse to avoid that hearing.
I completely understand, Judge, but the family court was in a position to say that these general admissions that my client was entering would constitute severe abuse under 384-B 8A1. And that perhaps would have solved the problem that's before the court today, but that didn't happen. The Article 10 order did not specify the statutory subsection under which a severe abuse finding was being made, and that then precluded the court from granting summary judgment under 8D in the TPR proceeding. And
do you agree, counsel, do you agree that a parent who is convicted of assault second, those are grounds in and of themselves to terminate parental rights if it's directed toward the child, the crime?
It is, Judge, under 8.
You don't need a hearing, you don't need reasonable efforts to reunite. that a conviction of that nature in and of itself results in termination?
Judge, I think that's true, but what a parent is entitled to is the basic due process requirement of an opportunity to be heard. For the judge to say, I am taking judicial notice of the fact that you have this attempted assault in the second degree conviction, the crime was perpetrated against the child, and do you have anything to say about why that should not be used to terminate your parental rights? And that's the bare minimum that I'm respectfully suggesting should have been afforded to the mother here. Instead, the court indicated that it was granting summary judgment under 8D, and then, at least as far as I can tell in the record, the court requested the guilty plea transcript and the indictment on January 3rd, which was the very day that the court issued its written decision, where it relied not only on 8D, but also on 8A3. If the court had said, I'm relying on 8A3, is there any basis for why I cannot consider this conviction in order to terminate your parental rights? Then I think this would be a very different case before this court. But I think, one, the mother should have been given that opportunity, and two, it appears that on this record, there would have been some arguments to be made why, under the circumstances of this case, that guilty plea in criminal court was insufficient, in that the admission in criminal court was causing physical injury within an extension cord, and I think it's reasonable to argue that an extension cord is not a dangerous instrument insofar as it's unlikely to cause serious physical injury or death under the circumstances.
But again, I agree with you. I question how in the world would they have been allowed to plead to these two crimes, but they did, and the remedy there, like here, it's a motion to vacate the admissions. There, it's a motion to vacate the judgment of convictions, which hasn't been made. So there's two problems. You got admission and you got a plea, and there are ways to challenge those at the trial levels that haven't been taken here.
I agree that is an option, but I think my argument boils down to is that the mother here was denied the basic procedural due process right to simply be heard on the evidence that the court was going to use to find severe abuse. And I think it cannot be denied that she was not advised that the court would be relying on 8A3 to grant summary judgment. That first came out as an alternative.
You're asking us, just to sum up, you want us to remit it, give your client an opportunity to be heard with respect to her plea, and then you're not saying necessarily a full-blown hearing, just it should be remitted so the court can proceed under the correct procedures.
That's correct, Judge. And
right.
for point two, I'll rely on the brief. Thank you.
All right, Ms. Hallenbeck.
Thank you, Your Honor. The department's position is that the TPR was appropriately granted under both provisions that the court granted it under. Just to, I think, go backwards from the way the court did it. In regard to the criminal charges that both the appellants pled to, the form of assault second, the subsection, is clearly delineated under 384B as a basis for a finding of severe abuse on the TPR. There were also reasonable efforts findings made by the court in support of its ultimate determination, because it found reasonable efforts up until, it was almost 2 years, up until the time that it determined that reasonable efforts were no longer necessary. And I think it was May of 2022. So that is clearly sufficient to support the finding of severe abuse under the TPR. Also, our position is that the initial finding was appropriate. And basically what appellants have done here is challenge the Article 10 finding. But as the court has pointed out, as several of you have pointed out, there's a clear-cut consent here. While the elocution may not have included all of the exact elements of severe abuse, the appellants were clearly informed that this petition was for severe abuse. The allegations of the petition, as far as the statements of the children that were attached to support the petition, were detailed and complete.
Counsel,
And
would you
as this
agree-
court-
would you give, Counsel, would you give Ms. Chadwick and Mr. Banaszak, would you agree with this much, that there's no evidence, well, first of all, that based on the admission, there must have been admitted conduct that that the parent showed depraved indifference to the child here, and that's an element, and there was no evidence of that. Would you agree with that much?
In their allocution, Your Honor, or in the petition? In their allocution, I would say that that's correct. I think they just admitted, I don't remember the exact words, but to excessive corporal punishment.
Right, and they didn't admit to serious physical injury being inflicted either.
I'm not sure whether that was included. I can't say, Your Honor, I'm
They
sorry.
admitted to
They admitted to
physical injury. Right, they admitted to physical injury, not serious physical injury, but.
Okay, I wouldn't contest that. That says probably, I remember there was language in there. I didn't remember the specifics. However, what they consented to was the allegation of severe abuse. And what they consented to was, in essence, everything that was alleged in the petition, or enough that was alleged in the petition to constitute severe abuse. And you can draw fine lines as to this child or that child or this activity or that activity, but overall, we're talking about excessive corporal punishment using dangerous instruments multiple times a week. And the children's statements were consistent. They were varied, and they were credible in the sense that they were varied in the details, but consistent in the overall pattern that those children were living with their parents. And there was also testimony or statements about the scarring that appeared on the children. And what constitutes permanent disfigurement, what it doesn't. If you get into a trial and you've got doctors or psychiatrists about severe emotional trauma, but we aren't there because they consented to severe abuse. And I think the court appropriately pointed out that what's going on simultaneously are criminal charges. That the more that comes out, the more evidence there is in a criminal matter that on assault second can result in a state prison sentence. So their choice to do what they did, I obviously wouldn't know what their conversations were with their counsel, but is not an unreasonable situation, or we don't have a situation where there was an isolated incident of excessive punishment that somehow got blown way out of proportion. This is the statements in the petition demonstrate an ongoing pattern of behavior.
Until the child was actually hit in a visible place on their body, the evidence of their abuse was hidden for a long time, right? Yes. On their legs, on their backs, but never on their face until the father flung a cell phone at a child, and that caused some inquiry. Okay, do you agree with my reading of the record that these children were terrorized by their parents on an ongoing daily basis, and they started to get their older children involved in such terrorism?
Yes. One of the statements of the children that was attached to the petition says that the parents were having the oldest two children, the boy and the girl, abuse the children in the same way that they had. So there's ongoing psychological terrorization or traumatization here. And we can't know exactly what effect that had because there wasn't a trial. But a reasonable inference is that this was severe abuse, and that their plea or their consent to a finding of severe abuse prevented the details from coming out and from testimony that could have been very harmful to them in the criminal matter, and that argument also really just goes to the ineffective assistance of counsel argument. Counsel, the record reflects that counsel in this case knew the case, spent time with their client, knew all of the facts in order to cross-examine witnesses at the dispositional portion of the TPR, presented a witness on his behalf, as well as the appellant father. There's nothing there that would indicate in the overall record ineffective assistance. And there is a logical reason why these admissions would have been made. And based on the simple, as you said, on the criminal matter, I would say that was sufficient.
Okay.
All right, thank you, counsel. Case 1020, Jonas versus Jonas.
Good morning, Your Honors. Kelly Farron for the
Just wait
appellant.
1 second. We're waiting for Ms. Connell, and she is here now, so you may proceed.
Thank you. Kelly Farron for the appellant, Sandra Jonas. Your Honors, this is a case where the lower court tries to portray the Jonas matter as a riches to rags story, and that's simply not the case. This has been a long-term marriage, 4 children, 3 of which were still unemancipated at the time of the filing for the judgment of divorce. 1 child suffers from severe disabilities as well. There's no doubt, and it's set forth in the record, that these parties and the children lived a very, very lavish lifestyle.
Can we fast forward just a little bit? It sounds like the big question in here at trial and on appeals, what happened to the money?
That's the
question.
question.
Where did it go? You have your position, your client's position is that the husband secreted it away, or he wastefully dissipated it, he just spent it lavishly on himself, or more likely, he's got it hidden somewhere. His position is there was a severe downturn in the economy, China started making the same brake parts, and the business just went down, and he put all that money into the business, foolishly. So that's really the main overall arching financial issue in this case.
That's our second point. That goes to the equitable distribution of what happened at the lower level. It's either theft or it's hidden and secreted. There was no evidence at trial to show for him to substantiate the downfall in business. I believe the trial judge even said that 2018, and why is that important? Because the the divorce action was commenced in 2018, took a drastic turn. Okay, you don't go from living in an 8,600 square foot house in Spalding Lake that took you over $2 million to build, with a 25 square foot, 8-car garage, another 2,500 square foot indoor swimming pool.
Well, counsel, there was some issues there with the bank, right? The bank made them refinance a loan, and they had to continue to pour money into this business to keep it actually up and running. I mean, there's no question about that. There is no SBB any longer.
There was, but it wasn't the bank that required this. Mr. Jonas did this. Mr. Jonas did this.
But the point though is, this was what was before the trial court. This was the type of proof that the judge was listening to. What happened to the business? What from 2007 to 17, and where did the money go?
The court also heard evidence where he took about almost $800,000 from the savings and checking accounts of the parties. There was no accounting for that. Basically, the trial judge looked at, okay, what assets do we have still available, and went forward with that. The court did not look at what was being done immediately and in years.
He ends up with the $500,000 deficiency judgment.
He does end up with the $500,000 deficiency judgment because of the $1.65 million SBA loan he took, unbeknownst to our client, who was also a business owner.
So your client wants us to modify the judgment here and issue a money judgment to your client for X amount of dollars, the money that she claims she would have been entitled to had he not hid it or blown it.
If this court finds that there's enough in the record to do that, absolutely. If not, it might have to be sent back for a new trial to further explore what was going on in this marriage and right up to the judgment of divorce filing.
That's why we had the trial, but it was a significant ruling that your client didn't have to pay any of the deficiency judgment to the tune of $461,000. That did sound like the court gave your client some consideration on these issues in that respect.
I don't know that the consideration was really given to Mrs. Jonas, because Mrs. Jonas was a woman who did not work. I mean, she did put her hands back in the business, but then she was gravely ill, and there's no dispute in that, for a period of 4 years where she basically could not get out of bed. and attend to matters. They even hired help for the children and for the household, Mrs. Jonas, to take care of her at the tune of, I think it was like $45,000 a year. So I don't understand how a trial court, when you're posed with a position where you have a man earning in the millions to a wife who was a stay-at-home mom and who also has severe illnesses, she's still undergoing the chemotherapy treatments, how she could even be responsible for any part of that when she knew nothing about it.
We understand. You want a judgment, a money judgment. He has no assets that we know about. It's not going to do her any good, but you would feel better if she had a piece of paper that said he owes you.
That would help her, but he also does have assets, because as was pointed out in the trial, there was a girlfriend, okay? All of a sudden, there are brake parts being taken from the business, and now he has an online business. Now that's in the girlfriend's name. Girlfriend's a nurse, always been, many, many, many years as a nurse. Now she's selling brake parts online.
Right.
So
Wouldn't that be more relevant to the maintenance and the child support, that he's earning this money and so forth?
that certainly is relevant to maintenance and child support. It also goes to, what is his true income in establishing equitable distribution and how do we distribute those assets. The other point that we set forth in our brief, our first point, was that the trial court basically abdicated its responsibility in determining the maintenance and child support obligations. Okay, the trial court has an absolute obligation under statute.
Even if your client consents to it? My understanding of the record is that your client and the husband both said, okay, we'll deal with those in family court.
That's not really what the record says. On day 3 of trial, and I quote from the record, the trial judge says, the issues of child support and maintenance are being referred to family court at the request of the county, as Ms. Jonas is now receiving public assistance. I think this is a clear abdication.
All right.
Even if there was
Can I ask you
consent.
this? The order that you're appealing from was entered more than 2 years ago. Have they not already gone to family court and dealt with child support and maintenance?
No. They have dealt with it on Mr. Jonas's applications to continually seek to downwardly modify. In fact, I think we have to be there tomorrow, yet on another petition to downward. They have not addressed the underlying petition. She has not filed an underlying petition to do an initial address of child support and
There's an
maintenance.
order from family court right now in effect, or is that a continuation of the Supreme Court order?
That's a continuation of the Supreme Court order at this point in
So
time.
the issue's being litigated, you just want to stop it being litigated in family court and bring it back up to Supreme?
It needs to be done in Supreme Court because that's the role of the Supreme Court. To go into your question, was there a stipulation? I don't believe that there was a stipulation. I don't see that language in the record. But even if there was, the court does not have to take that stipulation, and that's evident by the fact that the trial court did not take the custody stipulation, the written agreement, more specifically, of the parties and made a determination with respect to the custodial issues for this family. So I think there's a Fourth Department case, I think it's Labouré versus Labouré, where this court specifically found that in the trial court not determining child support, it abdicated its role. Child support and maintenance, lastly, cannot be determined in a vacuum, Your Honors. It has to be taken as a whole picture with respect to equitable distribution, support, and maintenance. And lastly, she borrowed $250,000 from her sister just to continue her basic minimum. She went from living in Spalding Lake to the trailer park. He's not providing support, yet he's out there living his lifestyle. So
you want the case, the maintenance and the support, your client wants to go back before the Supreme Court judge that she claims shorted her massively on the property distribution?
Well, it could go back to a Supreme Court judge, not the Supreme Court judge. It could go back to a Supreme Court judge to make that determination as to child support and maintenance, and also to address equitable distribution. That loan from the sister was taken because there was not enough financial support in the household. The kids couldn't finish Canisius High School. This is how bad it was. Yet, there's cars. He can't account for the cars. He can't account for anything. His 401k, he says, disappeared. What kind of explanation?
We understand. You want another trial. You want to start over.
I think that is the most appropriate remedy in this matter, Your Honors.
All right. Thank you.
Thank you.
Mr. McPartland?
Thank you. Michael F. McPartland for the respondent. Michael Jonas, Your Honors, I think there's no reason to disturb anything that was done in the court below. As for the first point, that it was error for the Supreme Court trial judge to refer case of child support and maintenance to the family court, first of all, they can do that sua sponte without the consent of the parties. Second of all, on the record, the trial judge said, on the record, in the virtual presence of parties and counsel, she was going to do that. Both parties said that they were fine with that. And even if they objected to it, no objection was lodged to preserve that error to bring it up to this court. So I think it's academic. The court was well within its rights to do that. As for the issue of the alleged failure of the trial court to properly equitably distribute the marital assets, I think there's case law that says that unless the court had an improvident exercise of discretion, it should not be disturbed. There was a 4, maybe a 5-day trial. I wasn't there for it, but a different attorney was. We've seen the record. Evidence was presented. Mrs. Jonas's version of the story is that Mr. Jonas hid all the money. Mr. Jonas's version of the story was a reverse Horatio Alger story. We had parties, a family that lived a lavish lifestyle. They had Spalding Lake, they had cars, they had the vacation home, and they also had a lot of loans that kept all that going. And as soon as Mr. Jonas's pay went down as a result of economic factors beyond his control, the whole house of cards came crashing down. So to go back and disturb what was already decided is tantamount to giving Mrs. Jonas a second bite at the apple. I think that the trial court's decision regarding equitable distribution was sound, and I think that this court should give some deference to that, and I rely on my brief for anything else. Thank you.
Thank you. Ms. Connell, on behalf of the children, wishes to be heard on the child support issue? You have to mute yourself there.
I'm in an awkward position because the trial agency did not consented to the child support and maintenance going to family court. As this court is aware, there are generally no AFCs appointed in family court on those issues. So I believe that's why I may have been appointed on this appeal. My clients do not see their father. Michael did have to go to another school. He's a brilliant, personable young man, and understands the court proceedings. My client Elizabeth is 15 years old. She does not quite understand the court proceedings. She doesn't see her father, and I do believe that she is not receiving adequate child support. But I didn't know what the court would want to know concerning the children.
Well, there's no custodial issues or visitation on appeal, so I think you were appointed just because of the child support issue. But did I hear you correctly to say that the AFC below consented to child support being determined in family court?
Yes.
All right.
Yeah.
And that's ongoing now. You're not representing the children in family court, but that's ongoing.
Right. No one is, although the Department of Social Services is still involved because there are concerns as to the actual assets of Mr. Jonas. So they are pursuing Mr. Jonas in that regard.
And you take no position on any equitable distribution issues? It's beyond your
I don't believe
purview.
AFCs. Right.
All right, thank you.
Thank you.
Case 1021 is Stephen L. versus State of New York. We have counsel for the state is appearing virtually. Ellen has submitted. Waiting for Mr. Brody. Mr. Brody, the appellant has submitted. Do you wish to be heard beyond your brief?
Yes, Your Honor, to a limited extent. Frederick Brody for the state as respondent. I'm appearing today just to take the opportunity to ask the court if it has any questions regarding this appeal. If the court has no questions, I'll rest on our brief.
Hearing none, thank you, counsel, for being available.
Thank you, Your Honor.
Case 1022 is Kraus versus Industry Matrix LLC, 1022.
Good morning, Your Honors. Michael Steinberg for Chad Krause. From an appellant's perspective, this is really a fairly straightforward case. And the court found that Mr. Krause had shown a prima facie case for liability under the scaffold law.
And why don't you go through those points? What did he show?
Sorry?
Why don't you go through the points of what he showed?
Well, he showed that he had been working on a roof, doing construction on a house which was not subject to any of the exemptions for owners doing their work on their own house, and that the ladder fell. He fell with it.
Did the ladder shift or fall?
It shifted and it ended up falling. I mean, the uniform testimony is it was on the ground.
Can I ask you this? If the ladder, would you agree with me that if the ladder doesn't shift or fall, and your client just misses a step and falls to the ground, that's sole proximate cause?
If the ladder is stable and he slips and falls off it and the ladder is still up there, yes, the case is a uniform. That's not a scaffold law case.
So your client, the evidence that the ladder shifted and fell came from your client and your client alone. It was unwitnessed. So
there is nothing.
Right. So, and your argument is because he stated under oath the ladder shifted, causing him to fall. The ladder then lands on the ground. The defendants have not refuted that in any way, shape, or form, has raised an issue of fact. Therefore, you win, even though the defendants couldn't possibly raise an issue of fact because nobody was there. So we just have to take your client's word for it.
We have, Your Honor, the sworn word of the father and the mother who both saw the ladder on the ground. The ladder got to the ground.
Well,
and it's consistent, all the evidence.
They were not deposed, though, correct?
Correct?
They were not deposed, the parents.
They were not deposed, but
right.
I'm
not saying you're wrong. I'm just making sure I understand. We have your client, his mother and father say the ladder shifted and the ladder was on the ground, game over, defendant loses, even though there's nobody else there. The defendant can't possibly dispute those allegations, and that's how our system works.
This court and all the other appellate divisions of the state have uniformly held that summary judgment is possible and, in fact, perfectly acceptable in the case of unwitnessed accidents.
The case is pretty clearly hold, Mr. Steinberg. I grant you that just by the fact that it's unwitnessed by anybody else is not enough to deny the motion. But there the courts typically, including our court, talk about whether or not the facts opposed to it are speculative or, I got to get the right language here, or if it's uncontroverted. But here, as I understand your argument, is that if a jury hears the facts and sees it your client's way, you win, no question about it.
Yeah.
But on the other hand, if the jury hears the facts and decides that maybe the credibility of your client and the others is not that great with respect to which ladder was used, with respect to whether or not he was under the influence, and with respect to what he purportedly said to a doctor who has not been deposed or whoever was in the hospital, that he misstepped, and that's what explained his fall. We don't really know how the ladder got down there either. The plaintiff couldn't recall. So if the jury believes any of that, then the defense wins, right?
The plaintiff can recall. The plaintiff did recall. As far as those other matters go, I'd like to address the one thing that the motion court found raised the possibility of sole proximate cause. And it has to be sole proximate cause because the negligence of the plaintiff, while it may contribute to the accident, doesn't exclude the statutory violation and therefore doesn't mean, it doesn't stand against summary judgment. Now, what we have here is double hearsay. We don't have the original note.
But you know, Mr. Steinbeck, our case law and case law from other appellate division that if it's not the sole basis for resisting motion, we could look at hearsay. And also relying on the hearsay thing, which I probably agree with, that because it's not pertinent to diagnosis or treatment. I get that. But that's all the more reason to say the motion was premature because shouldn't the defendant should be allowed to at least depose the medical person who wrote that in the chart?
For one
That's the
thing,
answer to that.
I'll get to that supposed cross appeal in a minute, because the issue of whether this is premature is not before the court and cannot be raised before the court.
Well, it could be an alternative basis for affirmance, Mr. Seibert.
Well, except it's not an alternative basis for affirmance. It's a basis for modification, because an affirmance would mean that the plaintiff cannot move a second time for summary judgment. But to say that it was premature will give him a second chance. So in fact, it is against the interests of the defendant. As far as the statement in the medical record, yes, it's hearsay, it's double hearsay. We don't have the original note. I'm sure we will never have the original note. So I'm not sure it could ever come in again, and it could ever come in at trial. As far as the other non-hearsay evidence, there is no other non-hearsay evidence that the accident didn't happen the way the plaintiff said it
Well,
did.
the way the judge looked at it and the way counsel here looks at it is that, yes, the medical records are hearsay. Can't admit them. But they are, you can impeach they can impeach your client with the medical records. And they say that's what happened during his deposition. He acknowledged the possibility that he might have said those things, that he missed a step and he landed on his feet. He said he didn't think he did, 90% sure that he didn't say those things, but that leaves 10% leaves open the possibility. That's non-hearsay, right? He's basically admitting, I might have said that. And that's non-hearsay.
He's saying he doesn't remember saying it, but I think my client is being penalized for trying to be too honest here. He doesn't have a memory of saying it. He can't rule out that in the state he was in at the time, he might have said that.
Well, if he knew for a fact, for sure, that he didn't misstep, he would have said, no, I didn't say that. But he left open the possibility. That is being honest, but that's what you're supposed to do at a deposition.
But if he missed the step and the ladder falls because he unbalanced it, he's in exactly the same position as the plaintiffs in the cases we cited at 27 and 28 of the brief, the Yaukin and the Morocho case.
Your argument is that it doesn't matter if he said he missed a step because the ladder shifted and those medical records don't dispute the shifting issue.
Correct. That is our alternative argument, that if it doesn't come in, if it does come in, it doesn't make any difference. And the additional non-hearsay proof that somebody thought he sounded like he had been drinking, and it was dark, which he worked in the dark because it takes things hardened up too fast in the sun.
What about the two-ladder theory? The father had made a statement that to the general contractor, and look, I'm sympathetic to your client. This is a ridiculous way to go about doing business, where the property owner hires a general contractor who has no insurance, who then hires it, subcontracts it out to two people. One guy has no license, another guy has no registration. Nobody has any safety. I mean, this is just preposterous. So this is why perhaps 240 is in place. Be that as it may, though, the father apparently says to the general contractor, because somebody's got to finish this chimney work.
Yeah.
Your client's hurt. The general contractor goes to the father, "You want to finish it up?" He goes, "Yeah," and he talks about the 40-foot ladder that my son fell from. I'm going to use that. They say, they put a lot of significance on that statement, that shows that your client was lying about this two-ladder setup. And the fact that they showed the ladders that he used, and they were 16-foot ladders. Couldn't possibly, so this ladder issue is part of it as well. How do you deal with that?
I think what the father says in a text conversation sometime afterwards, when in fact we know that Chad tried to use the 40-foot ladder the day before and got hurt by it, trying to get it around or get it down, decided he didn't want to deal with it. I think it has no probative value whatsoever. Throughout this case, there has been a very strong attempt by both defendants just to kick up a miasma of credibility issues out of all kinds of...
What in the record shows what happens to whatever it was the plaintiff used to tie off the upper ladder according to his statement? He tied it off around the chimney and he put blocks underneath the ladder. Is there anything the record explains what happened there?
I do not believe that there is, and since
Is that a question of fact too, together with everything else, in terms of what happened here?
I would submit that it does not. I mean, the ladder falls and the block presumably stays up on the roof and nobody bothered with it. It was night.
Did he fall, and I apologize, you probably know this, but does he claim he fell from ladder 1 or ladder 2? Ladder 2 being the one touching the chimney?
Ladder 2. He fell from ladder 2 because he was up by the chimney. And, you know, the testimony has been consistent. Everybody's testimony has been consistent. And you know, the Zuckerman says that you have to come up with proof in admissible form.
Counselor, can I interrupt you for a minute? Sole proximate cause.
Sole proximate.
Right. The defense position is that this accident was caused entirely by the fact that your client missed a step.
Mhm.
And your position is, well, no, he didn't have the appropriate equipment. Right? I mean,
yeah.
Right. So
our position is that...
What does the defense say as to how they provided equipment or satisfied their duty under the statute? What did they do under the statute to provide their duty?
They didn't do anything to provide equipment.
Okay, so how do you get the sole proximate cause when they didn't provide any equipment or satisfy their duty in any other way?
They would get to sole proximate cause if there was any shred of evidence. I'm not saying they would prove it, but they could establish a triable case that the plaintiff's acts were the sole proximate cause if he fell off a perfectly secure and stable ladder.
They have got to show there's a perfectly secure and stable ladder from the outside.
They have
to. That's their burden to get to the sole proximate cause.
They have to show some.
So if there's any question about the stability of the ladder, the quality of the ladder, or how it was put up or tied up or anchored, that's on them.
That is on them.
So that's not like we've got a supervisor on the scene who says, I can tell you what kind of ladder we used, it was a good ladder, it was safely secured, it was the right ladder, and the only reason he came off that ladder was because he did something wrong in using the ladder. That's not the case here.
If there was somebody who said the ladder was standing there unmoved, then...
And that's on the your position, that's on the defendant here to get to demonstrate they've satisfied their burden.
That's exactly how the motion court did it, and that's exactly, we submit the correct way of doing it. Was there a prima facie case of liability? Yes. Once it's a prima facie case of liability, the defendant has to come up with more than speculation or surmise. They have to come up with proof in admissible form that raises a triable question of fact.
That there's only one possibility, right? The defendant has to show just one.
It has to be absolutely.
So,
the statutory violation had nothing at all to do with the cause.
Right, to the extent that there's any confusion how the ladder was situated or tied off or anything, that cuts against the defendant here, not against the plaintiff.
I think it does cut against the defendant because it is, it's not a ladder that is properly secured is not a ladder that works only when the plaintiff is doing everything perfectly. You know, a ladder that's properly secured is secured against the ordinary risks of a work site, which is generally a messy place.
Your time is running low. Can I just ask one last question?
Sure.
With respect to the first question posed to you by Justice Del Conte? Would you agree that there can be sole proximate cause, an issue of fact, for trial, even if neither of the defendants, the general or the owner, provided any safety devices at all to the plaintiff?
No, that in fact, they have the obligation to provide the safety equipment.
Okay,
they can't get out by saying...
I thought you said when we started this conversation, when you first got up, if the ladder didn't shift or fall and your client just misstepped, then it goes to trial on sole proximate cause, right?
If there's any evidence that the ladder didn't shift.
Right,
yeah,
exactly. But who provided the ladder is irrelevant to that analysis. In other words, so a defendant, it can still go to trial on sole proximate cause, even in the absence of any evidence that the general or the owner provided the ladder or any other safety device, correct?
It would go to trial on the question of sole proximate cause if the ladder didn't move.
If, it's a big if.
Yeah, if the ladder didn't move, and who provided the ladder, I do not believe has any legal relevance.
Okay, thank you, counsel.
If I may?
Sure, I'm sorry.
Mr. Steinberg, I'm looking at the Brooke case, or excuse me, the Blake case, the famous one, one of the famous ones,
Oh, yeah.
Court of Appeals on this. And there, Justice Rosenblatt wrote, "It is conceptually impossible for a statutory violation which serves as a proximate cause for a plaintiff's injury to occupy the same ground as a plaintiff's sole proximate cause for the injury. Thus, if a statutory violation is a proximate cause of an injury, the plaintiff cannot be solely to blame for it. Conversely, if the plaintiff is solely to blame for the injury, it necessarily means that there has been no statutory violation. So the only motion we have here is your motion for partial summary judgment. Defendant merely opposed. It was your obligation to prove as a matter of law a violation, which includes defeating the sole proximate cause defense, correct?
We do not have the obligation to defeat a sole proximate cause in advance.
Well, why don't you have the obligation to prove proximate cause?
We can prove a statutory violation was a cause of the accident. And at that point, that does exclude the others. It is not, there's no obligation on the plaintiff to prove a defense.
Well, he's not talking about at trial, he's talking about on summary judgment.
I understand, but the obligation on the plaintiff is to show a prima facie case of liability. And if we show that the latter did not provide proper protection, in that it shifted, moved, fell, and the plaintiff fell as a result of that, then there can be no sole proximate cause.
Would you agree that sole proximate cause is question 2 on the verdict sheet, or is it embodied in the violation question on question 1? Now, that's a loaded question, Mr. Steinberg. You know what? Let's make that a rhetorical question for me, and we'll just let it ride.
Okay.
I don't think you argued that. That's not fair to you. Forgive my question.
Thank you.
Thank you.
Mr. Palzer?
Yeah. Good morning, Your Honors. Matt Falzer for the defendants. It sounds like the court thoroughly has the arguments from the briefs.
How about this last issue on burden of proof for sole proximate cause on summary judgment? Plaintiff moves for summary judgment. The defendant doesn't cross-move to dismiss, but just says, issue of fact on sole proximate cause. Mr. Steinberg says you have the burden on that, even though he's the moving party, and traditionally the moving party has the initial burden.
Sure. I would disagree, Your Honor. That's not how summary judgment works. The plaintiff has the burden of showing a prima facie case. We show that there are issues of fact. That's all we had to show.
So why don't you tell us what your issues of fact are?
Well, first there's the hospital record, right? And there's a difference between, just showing, on the motion, just submitting the hospital record and what it says. There's a difference between the document and what someone's sworn deposition testimony is about a document. And that's one of the things we showed here. And he was cross-examined at the deposition. He had the opportunity to say no several times. I did not say that. He said, I'm 90%
sure, right.
Right, and I think the last thing he said was, when you're lying there, you'll say pretty much anything. That's the equivalent of saying, yeah, I might have said that.
So it goes to the weight of it. Would you agree, though, that those records are hearsay, straight up hearsay, if not double hearsay, medical records?
I would agree that the record itself would be hearsay. Okay?
But his answers in response to questions about the records under oath are not hearsay? Is that your position?
They're not. I'm asking, did you say this to the doctor?
All right, well,
and he essentially said, I might have.
All right, so then, giving you the benefit of the doubt on that, then there's an issue of fact as to whether he missed a step and fell.
Yes.
But the medical records are silent as to whether the ladder shifted, as the plaintiff claims under oath. So Mr. Steinberg says, it doesn't matter if he missed a step, it shifted, he wins.
I wouldn't say necessarily that they're silent. It says, he fell tonight because of the darkness and he missed a step. It doesn't say that the ladder shifted as well. And so when we asked him, did you tell the doctor you fell because you missed a step? And he said, I might have, essentially. There's the issue of fact.
We all know no doctor's going to come in and be able to recite exactly what the plaintiff said to him. They're all going to say, well, I wrote down what he said. That's 99% of what a doctor would say if they were asked. So all we have is the possible admission of the plaintiff that he's 90% sure that he didn't say that. And so on that 10%, I guess I'm saying, is it your position on that 10% that he might have said that? We're supposed to hold this case up. And
if you're looking at just that line in the transcript alone, that I'm 90% certain, but he also said, I can't be 100% positive. When you're lying there, I might, you'll say just about anything. But I don't think that's all we have in this case. That's just the medical record.
Okay, then I start out by asking you that question. What do you have? Sure. And you started talking about the medical record and his deposition commenting on that medical record.
Sure.
You have something more that we
Sure.
should?
Well, a hearsay statement can, be used at summary judgment to defeat summary judgment if it's submitted with additional evidence.
So I'm asking you.
Right, and so the additional evidence, and I think his testimony about the medical record alone is enough in this case to defeat summary judgment. But also, if you take the statement of the medical record plus the other evidence, which is that, there's people who have smelled his breath and think he was drunk.
What people were those?
There were tenants living in the house, so he
I don't know if
knocked
they
on.
smelled his breath, they just said it sounded like his words from his, I don't think there was any odor of alcohol alleged, just his speech pattern, right?
That was the one witness, Your Honor. The other witness said, I believe that he smelled like alcohol.
All right, so you claim that raises it. What else you got?
Right, so, the question of did he fall off the ladder, I think it's very possible he could have when, he's working long hours, day and night, he said. He had been on a ladder at a different job at the beginning of the day. Now we're already going from the beginning of the day all the way into past midnight when this accident happened. He's going up and down the ladder 35, 40 times, carrying buckets. He's missing his left hand. He's only got one hand. There's also the issue, could he have been mentally and physically exhausted and made a lapse of judgment and missed a step, in a light most favorable to the defendants? Yes, he could have. Also, just as a factual argument, when you look at this claim 2 ladder setup that he has, the roof over the staircase ends before the peak of the roof. You don't need an expert to see that and based on the photograph evidence. So how could he have reached the ladder?
If you could just stay in front so everyone.
How could he have reached the chimney when the ladder's off to the left and he's missing his left hand?
But counsel, isn't that the issue of sole proximate cause? You're making the point that don't you have to eliminate every other cause except the worker's own responsibility here for this, right? If this is not the case where your client is affirming he had a good ladder, was all set up, it was perfect, and the only explanation for his fall is that he did something wrong.
Well, if there's questions of fact about how the accident happened,
no,
that's a different from.
But that's the question. Don't you have a burden here of demonstrating that the worker is the sole proximate cause? To the extent that there's confusion as to how this accident happened, that cuts against you, doesn't it?
I don't believe we have a burden of proof. We have a burden to raise an issue of fact, and I believe we did that by him saying, well, I might have made that statement.
But you can't say that he had adequate safety equipment. Because you didn't provide any equipment. Your client didn't provide any equipment, any safety devices, and no one else did.
The case law is that from all the way up to the Court of Appeals is that just somebody missing a step and falling off of a ladder alone is enough to raise an issue of fact or sole proximate cause, just a ladder. So did he have safety equipment? Yes, the ladder.
Right, but your argument, as I read the brief, was that he really used the 40-foot ladder, his dad's 40-foot ladder, right? That's what you believe. And there's some serious evidence to support that.
Sure.
It's also your contention that that ladder was defective. There were some problems with that ladder.
It could have been.
Well, I think the plaintiff testified, he was complaining about his dad's ladder. It fell the day before and hit him. It was missing some part of it.
Right.
So I'm not sure how it helps you if the plaintiff was using that 40-foot ladder because that was not sufficient for the job, and it's the general and the owner who have to provide adequate safety devices. And this ladder you're claiming he used, now Gret, he says he didn't use it, but if he did, it doesn't seem to help you.
I think that all falls into the credibility issue, right?
And there's a
I
case
think
we
that's
have
the
called
argument.
Piotrowski, Mr. Falzer, from somewhere in the early 2010, somewhere in there, where the allegation for sole proximate cause was that the plaintiff had chosen a wobbly ladder. And there were other ladders available, so if you choose the wrong equipment, it might still be sole proximate cause. I'm not sure of that, but I think that's what that case seems to hold. We set it back for another trial.
I believe so, yes.
Anything further?
Nothing further.
Thank you, counsel.
Thank you.
Case 1023 is Skyalko versus Alecki.
Good morning, Your Honors. If it please the Court, Richard Collins appearing on behalf of the Alessi appellants. In this case, We are asking the court to reverse the granting of a motion to dismiss because the privity doctrine, which was used to dismiss the complaint in the cross-claim of my client, we submit, isn't applicable to at least the record that's developed in this case.
Mr. Collins, if I read it correctly, this is a pretty, what I would consider interesting, unique question of law. We've got to really dig in on this one and decide if there's a duty here or isn't there. That's basically, I don't mean to steal your thunder, Mr. Collins, but we got our homework to do is what you're telling us on this duty issue.
Yes, Your Honor, and I hope I've helped a little bit, but it seems to me, for the first time in all of these years, I can say that I'm representing somebody possibly in a case of first impression.
Right, because the rules as they exist now, there's no privity, and then there's no negligence, there's no duty there, but you're saying in cybersecurity cases, we should, given the unique dangers with cybersecurity, that we should create a new rule so that if you are a professional such as an attorney, and you don't take adequate protections to protect your computer system, and you get hacked, and somebody else is injured thereby, the lack of privity should not bar a lawsuit against the party who didn't take adequate steps to protect.
Yes, Your Honor, that's the argument.
Right, and that would be something really that the Court of Appeals or the legislature might have to do.
Yes, in our argument, we rely on the criteria that the Court of Appeals announced in the New York City asbestos litigation, where they set forth different categories of consideration. Economic impact. So one thought would be, and we would certainly assert, that it's not imposing an undue economic burden on an attorney to have adequate cyber security protection. Scientific development, I think that this case should have gone forward so we'd have a better record. We didn't have a chance to question, for example, the Alecki defendants, what type of protection do you have on your system?
Or really, we need to know who was breached.
Yes.
Mr. Alessi says, well, it's not clear whose computer was breached or both.
Correct.
In your view.
Yes. And also, we don't have, I would acknowledge, no expert opinion yet or expert evidence to those ends or to the economic impact aspect of it. There seems to be a sore need, if I can jump to the policy criterion in the New York City asbestos litigation, there seems to be a clear need to have some kind of instruction for attorneys to follow in terms of how does one fulfill that duty. I think there needs to be some kind of a duty. I don't think I'm alone in that. I think that duty for adequate cyber security protection tracks Rule 16 of the Rules of Professional Conduct in this state. And also, now we licensed attorneys have to, as we should, receive some instruction in continuing legal education.
Counselor, is part of your position that it really was pretty easy to detect with any basic knowledge of fraudulent emails? I mean, the account that was listed here is, you know what I'm saying, it didn't have a .com, it had a .co, it's the type of things that you're alerted to. You understand what I'm saying?
Yes, Your Honor, but certainly the argument that we're advancing to the court doesn't absolve the Alessi defendants from negligence. But if
But you still have the privity problem.
yes, we have the privity problem. But if, I just wanted, as the record now stands, it could have been the Alecki defendants' cybersecurity system that was inadequate, and that's where the hacking occurred, if you will, through that system.
Would you acknowledge that there were some allegations made that emails were sent to Mr. Alecki's real email, and it turns out not to be the case? That there were some allegations
There was a
made by your
complaint
client.
allegation
And
that
that's- and you're-
the plaintiff's attorney withdrew, it's in the record, withdrew, and it's certainly not any part of our argument.
All right, so you've withdrawn that.
Yes.
You're also withdrawing the theory that was articulated below in motions that somehow Mr. Alicki's response to the August 11th, 2021 letter showed negligence somehow, and that you've withdrawn that. That's gone.
Well, Your Honor, I withdraw it for purposes of this argument. I think that may become relevant if, again, we were able to proceed to discovery.
Okay. But for us to get there, you want us to carve out a new rule, announce a new rule on privity for cybersecurity cases, and it's not an unreasonable request. We'll take a look at it.
Thank you, Judge. Thank you.
Good morning, Your Honors. May it please the Court. My name is Christina Eaton from Connors LLP, and I am here to speak for Attorney William Alecki and his law firm. This is a case where the motion court got it right. If there were ever a case of no duty, this is the one. And as the court pointed out, the question of duty is one for the courts. It's a question of law. And when you look at the record before us and when you look at the law, the applicable existing law today, Attorney Alecki owed no duty to either Attorney Alessi or to the plaintiff, Gary Scalio. And I do just want to point out that the sole claim on appeal today is Attorney Alessi's cross-claim, which requires, at a minimum, a duty to either Attorney Alessi or to the plaintiff, Gary Scalio, and that the Alessi defendants are not arguing that Attorney Alecki owed them a duty directly, and nor could they, because the law states that an attorney, as a matter of law, does not owe a duty to an adversary, to opposing counsel. And if you look at the facts on the record also establishes that Attorney Alecki owed no duty to the plaintiff, Gary Scalio. It is undisputed that Attorney Alecki was not Mr. Scalio's attorney. It is undisputed that Attorney Alecki was Mr. Scalio's attorney. It is undisputed that there was no privity here between Mr. Scalio and Attorney Alecki. It is undisputed that Attorney Alessi it is undisputed that Attorney Alecki was never in possession or control of the $225,000 at issue in this case, that he was not the party who wired the funds to the imposter, and the record establishes that Attorney Alecki was not involved in any of the email communications that form the basis for the complaint.
I agree with all what you said. I don't think it establishes as a matter of law that your client's computer wasn't hacked. There's a lot of evidence indicating that it wasn't, but we're on, that would seem to be a matter for discovery and for trial. But we don't even get to that if they can't get beyond duty.
That's correct, Justice Lindley, and I do agree with you, if I didn't mishear you, that the facts on the record don't really support that Attorney Alecki's system was hacked. However, yes, you are correct that it wouldn't matter.
It does show that Attorney Alessi's computer was hacked.
That Attorney Alessi's email was hacked? Yes.
Yes, that's where all the evidence tends to point, but I don't know if we can just say that categorically on this record. There's still a slight chance that maybe Attorney Alecki's computer was hacked.
Well, and I don't think that you need to do that, because the law in New York is that an attorney is not liable for negligence to a non-client third party for acts and omissions that occur in the scope of their representation of their own client, and that's exactly what we have here. Essentially, as I understand the Alessi defendant's theory of liability, it's that Attorney Alecki is somehow responsible for for Mr. Alessi communicating with the fraudster, transferring the funds to the fraudster, because as best as I understand it, it's that Attorney Alecki and Attorney Alessi were emailing one another about the settlement, that Attorney Alecki's email account was hacked, which, just to be clear, is speculative, conclusory, and not supported by the record, but that because they were emailing one another, the imposter was somehow able to go on to communicating with Attorney Alessi. But the only reason that to the extent that Attorney Alecki and Attorney Alessi were emailing with one another, the only reason that they would have occasion to do so would be in the course of settling the Robnet claims, meaning that it would have occurred in the course of Attorney Alecki's representation of Ms. Robnet, and therefore there'd be no duty as a matter of law.
Do you care to, before you sit down, address the Toretto case that he relies on, the federal district court case, that on the privity issue and the duty?
Yes, I would, Your Honor. And the Toretto case, and I agree that Attorney Alessi's argument is almost entirely premised on that case. That case is completely inapplicable here. First, it does not involve the question of whether an attorney owes a duty of care to a non-client third party without privity, and that is the issue before this court. It's also factually distinguishable because in Toretto, which involved a class action, the defendants in Toretto were directly contracted with the shareholders from the plaintiff companies, meaning that there was at least some semblance of privity in there. And also, if you look at the Alessi defendants' attempted application of that case, it's completely an opposite. The Alessi defendants state that just like the plaintiffs in Toretto, Attorney Alecki possessed or stored Mr. Scalio's personally identifiable information. Well, that's nowhere on the record, and it's not even alleged in the complaint. And not only is it not on the record and not alleged in the complaint that Attorney Alecki ever possessed Mr. Scalio's information, there's no allegations of the complaint that any of the harm was caused by a breach of personally identifiable information. And we would submit that the Toretto case is completely irrelevant. And I also do want to briefly address the asbestos case that the Alessi defendants cited to. And again, that's an opposite here. It has to do with that case has to do with products liability. It has nothing to do with the question of whether an attorney owes a duty of care to a non-client third party without privity. But to the extent that the Alessi defendants seek to rely on the framework in that case, and specifically what I'm pointing to in that case is this theory that it's the person who's in the best position to prevent the loss should be held liable. It is indisputable that it's Attorney Alessi who was in the best position to prevent the loss here. He was representing Mr. Scalio. He was responsible for representing Mr. Scalio's interests. He is the party who was communicating with the imposter. He is the party who received the subject funds.
He's the one who got scammed.
Pardon?
He's the one who got scammed.
Yes, that's exactly right, Justice
All
Lindley.
right, we understand. Thank you very much.
Thank you.
Case 1024 is Howard versus the Reserve at Spalding Green. 1024.
Good morning, and may it please the court. I know you're tired, and we've all been here a while, so I'll keep it short. The trial court just got it wrong. We asserted two claims in our complaint, one for breach of contract, one for private nuisance. The court dismissed the breach of contract claim seemingly because the plaintiffs had not signed that document, but the document refers to to the other document that was signed, which was in the record. And also, they performed the duties and obligations required under the contract. And
The court
they
relied
paid.
on, the court relied on documentary evidence, correct?
Yes, Your Honor.
It's your position they didn't utterly refute the allegations.
Exactly correct, Your Honor. Some of the documents seem to support what defendants claim, but other documents support exactly what we claim. So I don't think either side can conclusively rely on documentary evidence.
But your main legal point is that offering plans are contracts, even if they're unsigned.
Yes, Your Honor.
If the law were otherwise, then your client wouldn't have to pay any assessment fees and could tear down the house and build a 5-story house. That your position is that even though there was no signatures, when you buy a house in a development of that nature, a condominium, that is a binding contract, even if unsigned, and there's issues of fact as to whether the neighboring property was built in conformity with the offering plan. What about the argument that they make beyond that is that the offering plan was amended, I think it was the 10th Amendment, that was filed with the Attorney General, and therefore it was in conformity with the amended offering plan. Then we get to the issue of do your clients have to consent to that modification? Do you wish to be heard on that alternatively?
Yes, Your Honor. First of all, thank you for stating my argument better than I did in 2 briefs. Second of all, the defendant respondents did get the amendment approved by the Attorney General, as is required. But the amendment also has to be approved by the homeowners already in the development, and that they didn't do. That goes back to the documentary evidence issue as well. I think whether getting the Attorney General's approval is sufficient, that's a great issue for a jury, but that's not an issue regarding whether we've stated a claim or not in our contract.
They seem to suggest that your interpretation of the agreement is just unreasonable because then anytime a property is going to be added, in other words, there are going to be how many, 50 units in this development, they'd have to go around and get everyone's consent. It's just not workable, it's impractical, and that's not a reasonable way to read that consent provision.
Well, if you accept their reading of it, Your Honor, then no one ever has to agree to the offering plan, to the contract, because they can just say they amended it without.
It would have no meanings. All these rules about you can build certain
Why even have the document?
Any limits would be irrelevant. I mean, who would ever buy there if it could just be changed without your consent? But either way, there's a reasonable disagreement as to how that's interpreted, and you believe that that can't be resolved on summary judgment.
It can't be resolved on a motion to dismiss.
On a motion to dismiss, even worse, yeah.
It should be resolved on summary judgment.
Gotcha. Okay.
And I'm sure if we go back and we do discovery and we make motions, that issue will be addressed. Thank you, Your Honor.
Mr. Jacobson?
Good morning, Your Honors. I represent the reserve at Spalding Green. One of the things I'd like to point out this morning is what you just asked Mr. Russ about was the offering plan. The offering plan was never signed by Mr. Russ's clients, nor was it delivered to Spalding.
Counselor, are you saying then that if the plaintiffs had signed the offering plan, that would be good enough, there would be a contract, and they would be a party to it and the beneficiary and obligated by the terms they're in?
No, I'm not. What
difference does it make whether they signed it?
Correct, Your Honor. That's absolutely.
That's the key argument that a juror makes, is they're not a party to it. You make the alternative argument based on the amendment. But to me, I'm like, what are we talking about, a signatory? The question is whether, as a matter of law, this offering plan is a part of the contract under which plaintiffs took title to their premises, right?
That is correct, Your Honor.
And isn't there case law that says, yes, it is? And following up on the Justice Presiding's questions, doesn't that make sense under the law?
It does to a certain degree, Your Honor, but here's the thing. My client did not have anything to do with Mr. Russ's client. They never met, they never spoke, they never did anything. My client developed a project, and the project is 50 homes in the Spalding Green subdivision, and those lots were sold as condominiums. That offering plan was put together by my client as a way to send to the builders that are going to be involved in the project, is just a document that's going to say, here's the form of the contract we're going to use, here's the terms that are going to be used, and you need to get your clients to the builders to sign along with this document. Mr. Russ's clients did not contact my client. They had nothing to do with my client.
Right, I understand that argument. What would you say if the Howards, under the offering plan, there are certain rights and responsibilities going both ways? I would assume that if you own a condo in this development, you have to pay homeowners assessment fees for plowing and other fees, right?
Correct.
There's other obligations on the homeowners. You can't build whatever you want, correct? What if the Howards were to say, oh, we didn't sign it, we're not paying you any money. We're not paying any homeowners fees. We're not restricted in any way, shape, or form by this offering plan. They could do that?
No, Your Honor, they cannot do that.
Why? How is it binding against them, but then not the other way?
Well, the problem is that the Howards, when they went and they purchased their lot, they went to a builder, and that builder was the party who signed the contract with them. And that contract specifies that there are maintenance fees, that the plowing is going to be maintained, that the lawns will be cut, and all those types of things. And if they want to live there, then they have to agree to those terms and conditions.
All right, so the contract was with the Howards and the person who built their property, not with the reserve and the Howards?
Correct.
But then how would the reserve, but you're admitting then the reserve would have no cause of action against the Howards for failure to pay homeowners fees?
No, the reserve would have a clause of action against the Howards for failing.
What about if the Howards sell to the Smiths?
I believe that they would still be
underneath.
I believe the Smiths would be trapped under the homeowners agreement as well.
Under what document would the Smiths be trapped?
Well, there's a contract between the Smiths and.
We're talking about second order, because this is a covenant. This is a relationship between the condominium developer and the property owner.
Correct.
You're saying it's not necessarily binding.
No, if I've said that, I apologize. What I'm trying to say is that the agreement that was signed by Mr. Russ's client and the third-party builder, who's not a party to this litigation, was a document that has to be transferred when the parties transfer ownership of the property.
So it doesn't run with the land?
It does run with the land.
But you need another separate document?
Correct.
To make it run with the land?
Correct.
Would you agree there's at least issues of fact as to whether the neighboring property conforms with the offering plan before it was amended under the 10th Amendment?
Well, the 10th Amendment sent that plan to the Attorney General's office to be reviewed.
Prior to that?
Well, no, because it had never been submitted and approved.
Right, so the plaintiffs have established that the house built next door to them violated the rules and regulations for building a house at that time, before it was amended?
Correct.
When they bought the house?
Correct.
Okay.
Correct.
Too big, to various other problems, too close?
Right.
Okay.
That's correct, but the Moschides, who built the house next door to the Howards, before they built their house, they came to us as attorneys and they said, this is the house we want to build. And it's whatever, 3,000 or 3,500 square feet, it's 30 feet tall, and you have to send this off to the Attorney General, which we did. And we sent the architectural blueprints, we sent an engineering report, we sent all those documents off to the Attorney General, and the Attorney General's office came back and said, okay, fine, you can go ahead and sell that home.
Did you get consent from the Howards?
No, we did not, Your Honor, because we didn't really think that language in there regarding consent is really not relating to a house that's under construction. It relates more to the fact that if the Howards or the Moschides decided to put an addition on their home at this point in time, then you would need to go out and go to your neighbors to get their consent.
Okay. All right. Thank you very much.
Thank you.
Court, Frank Jacobson from Ralph Larigo's office, here on behalf of HDJ Builders, Inc., or Jurek Builders, as their DBA is. You can see that the two respondents have taken different views as to this appeal, and we actually have differences as far as interpretation of the contract. I don't know if I'm hearing the court right, but I've never heard that parties who don't sign a written contract are parties to that contract. I mean, that I don't think is a valid argument, which is exactly what the appellants have been trying to say, is that they're somehow party to this.
Mr. Jacobs, it's the same question for you. Your argument is they didn't sign, game over. If they had signed, then they're in the game.
If they signed the actual operating agreement, yes.
Okay.
But
The offering plan, whatever the signature page is, whether it's all blank on the record and whatever the page is, 256. If they had signed that, then the terms of the offering plan would apply to them. That is because they're the beneficiary of some of the provisions, and there's obligations that pertain to them. Correct?
Well, Your Honor, here's the thing about the offering plan. It speaks of obligations, but as between the developers and the builders. That's who the obligations flow to. Those are the parties to the contract. Those are the ones that can enforce the contract.
Whether they signed it or not makes no difference.
Between the builders, it does make difference. They can't sue everybody who's signed that offering plan.
Your argument really is they're a non-party, not a non-signatory.
They are non-party to the agreement, correct.
So even if they had signed it, it would have made no difference.
Well, when you say they signed it, I presume that you're saying that they are then a party to it, that they would have been named somehow on the party. I mean, just actually ministerially signing doesn't do anything.
I'm following up, in my mind anyways, to Justice Presiding's questions. There seems to be in the offering plan obligations that would be imposed upon people like the plaintiffs that would be embodied in the offering plan.
It's obligations from the developer to the builders and between the builders to enforce amongst themselves. Because this is about really, this is the development plan.
So there's no obligations for the people who buy the units?
They have separate obligations because now they sign on with one of the parties to the actual agreement, who then can enforce that agreement. Okay, and that then
That's the
is.
builder?
Pardon?
I'm sorry to interrupt again, but is that the builder?
That is the builder in this case. That was that Kelkenberg Homes, who is not a party here.
Is it the builder only that can enforce?
This particular agreement. There are other agreements, like a homeowners association agreement.
Mr. Jacobs, hang in there. I'm sorry I'm not being very clear, but I'm following up in my mind again on Justice Presiding's questions about what are the obligations on the plaintiffs? You're saying the only obligations of the plaintiff, this is how I understand it, the only obligations on the plaintiff are those contained in the contract with the builder. The offering plan is irrelevant to them, they have no obligations under them, and you can't enforce the offering plan against them because they're not a party to it. That's what you're telling us.
That's what I think contract law specifies, is that there's a contract.
If the builder does nothing, that they decide to put on a turret on their house, so that, 20-foot turret, and let's assume somebody get building permit for it. You're saying that your client, the other client, their respondents can't do anything about it. You got to go get the builder to sue.
We can sue the builder. That's for sure. There are also other agreements that are entered into that run with the land. For example, a homeowners association agreement that gets signed and recorded that says what they have to do in there. Essentially, again, we talk about the terms and conditions. This was one of the arguments. This terms and conditions got incorporated into the construction agreement. Well, that didn't bind Jurek to that. It didn't bind the reserve to that. It bound Kelkenberg to it. It bound the appellants to it. They are parties to that agreement that incorporates, but it does not make us parties to it. It does not make them parties to the underlying agreement. That is only an agreement between the actual developers and builders.
I'm reading here's a third department quote. It says, an offering plan is a contract between the sponsor and the unit purchasers. I think you would say you might agree with that if the unit purchasers actually sign the offered plan.
Correct. And the court earlier, I think it was Justice Curran, said that there are lots of cases out there saying this. Well, they're saying it in cases where they actually were parties to the agreement. They were between the developer and the actual contractors. Those cases don't actually apply in this case, and that was simply dicta in that case. But what was going on in those cases is the people wound up being actual parties to the agreement. So there you go. I mean, again, this is basic. I hate to say, like law school, contract law, that parties to an agreement are the only ones who can enforce the agreement. And they're not parties. They are parties to an agreement. The appellants are parties to an agreement with Kelkenberg, and therefore, between them and Kelkenberg, it can be enforced. There's an agreement between Kelkenberg and Jurek and the Reserve, and they can enforce it. The arguments, I mean, I thought that a major argument would be about a third-party beneficiary, because, of course, that was something that the appellants argued. But, again, even where you're talking about third-party beneficiaries, they have to be specifically contemplated and named in that underlying agreement. In this case, they're building years after the agreement's been signed, and there's as I said in my brief, in the absence of express language, those parties are simply incidental beneficiaries who can't enforce that agreement. They can enforce only their agreement with Kelkenberg. As to the issue of private nuisance, this again is a case where I think the case law is pretty clear, and I'll just quote from my brief what was stated, and I think which is key here, is there is no right to light and air, and someone can't complain when those things are obstructed, quote, by the erection of buildings on adjoining land, unquote.
Okay, it's usually water, and so forth, for private nuisance.
Correct. Well, correct, that is true, and that's a separate allegation that's been made, but specifically here, light and air were actually mentioned several times in their complaint. Water mentioned, the word itself appears only once in their complaint. But as far as light and air goes, I mean, even the case cited and cited over and over again by the appellants, which I think was also cited by our side as supporting our side of the case, is this Doyne case, D-O-I-N. And in that case, there was a fence and a boat lift that was built on property. The boat lift was like 20 feet in the air. And there's the distinction right there, is that it's a fence and a boat lift, okay? There's not an erection of a building. In this case, we have an erection of a building, which goes along with the general rule. Fences and boat lifts are an exception to that general rule. And by the way, there's actually a statute that so says. Real Property Actions and Proceedings Law, Section 843, says essentially that fences or such structures are, if they're more than 10 feet, per se, a private nuisance. Buildings, however, not. And that's what we're talking about here. As far as the water goes, I think the court understands the argument there. It's only mentioned one time. There's no allegation, which there would have to be, that there was some man-made obstruction causing the water. Keeping in mind that in all of this, both causes of action. We have the Attorney General here who's approving everything, putting its stamp of approval, making sure that the plans meet the standards. There's building permits that are being issued. There are certificates of occupancy being issued. All of this, there's been no allegation that any of those things have been violated in this case whatsoever. Therefore, the lower court's decision should be affirmed. Thank you, Your Honor.
Thank you. Case 1025 is Vial versus Western New York IT Services, Inc. 1025. Good morning.
Morning, Your Honor. Your Honor, Paul Joyce for the appellant, Mr. Vile. I'm going to focus on Judge Walker's statement that by voluntarily resigning his employment with Velocity, Mr. Vile forfeited his right to the sale bonus. This case is about the retention bonus agreement between Velocity and Mr. Vile. There are two bonuses, sale bonus and an annual retention bonus. Judge Walker used the word voluntarily resign. Voluntarily has nothing to do.
Right, it's just simply as a result of the sale.
As a result of the sale.
Not voluntary. He says, the trial judge said in his decision, it went to the statement of the stipulated facts, and it says, he said it was stipulated that your client voluntarily resigned. That's not what both stipulations said. Neither one actually said that. But in any event, in your view, they're writing into, the court wrote into a voluntary phrase into the agreement that does not exist. It's simply, as a result of the sale, does he still work for Velocity? You believe there's some issues of fact there, that his old company really didn't cease to exist in the same manner. There was no work for him in his capacity. The jobs that he did, they didn't need him. So there's a view of the evidence that as a result of the sale, he wasn't working there anymore, and therefore he's entitled to this commission.
I'm going to go one step farther, Your Honor. As a result of the sale, he could not work for Velocity, because under the asset purchase agreement between Velocity and Deluxe, section 4.4C, it says Mr. Bilo and Velocity cannot hire or solicit any employees who've worked for Velocity in the past 12 months.
Well, there's 4 of them that stayed.
All family members, Your Honor.
Right. So they were excluded from the APA?
I don't know, Your Honor. Mr. Bilo was not involved in the APA.
Well, the APA is in the record, right?
It is.
So 4 stayed, all family members, his mother and father and...
Mother, father, uncle, and Mr. Bilo.
And they had this data center that they retained. And you're saying that under this agreement, this purchase agreement, Vile he could not work for Velocity, he had to go with Deluxe, or he couldn't work for either, right? Or was he bound to work for Deluxe? I mean, we don't have indentured servancy, but he could not have stayed with Velocity, you're saying, under this agreement?
Correct. He was not bound to work for Deluxe. He did go work for Deluxe because what he had worked on when he was with Velocity, the software, the portal software, was sold to Deluxe. So he went with that. But he could have also not worked for either.
And Counselor, his work really was for the purpose of getting paid. He wasn't going to get paid after the sale, right? Because it was the annual bonuses that was substantially his income.
Yes.
Right. So what was he to do? His job had left. It was gone.
Exactly.
That's your point.
Yes.
Right. Matter of fact, I think I might even agree with you if Velocity offered him a job at, say, $40,000, so you can stay with us for 40, or you can go with Deluxe and make 200 and you get stock and so forth. No, I think I'll go with a higher money. That's as a result of the sale.
Mm-hmm.
He chose to go here. Voluntary doesn't seem to be part of the analysis. I'm not saying necessarily win, but this focus on the term voluntary by Judge Walker is outside the terms of the agreement.
Yes. And the only thing I would correct Your Honor on is the stock. So part of the issue is ownership interest in Deluxe after the sale.
You get the stock later.
Okay.
Yeah.
Well, I'll address the stock.
Yeah.
He did not, Mr. Vile, in his affidavit in support of the motion for summary judgment, said, I did not get stock when I got this job offer from Velocity. Later, as a corporate-wide initiative, the publicly held company, Deluxe, gave everybody stock. He didn't have a choice. So, and that was a year after the sale. So I think under the agreement, he should have already been paid the sale bonus by that point.
Right. This provision seemed to be intended to prevent him from being the one to buy out Velocity.
I believe so, Your Honor. Unless the court has any other questions.
Thank you.
Thank you.
Mr. Burke, good morning.
Good afternoon, Your Honors. May it please the court. Kevin Burke from Gross Schumann in Buffalo, New York. I represent the defendant and the respondent, Western New York IT Services, Inc. I'm going to dive right into where Judge Lindley left off on the voluntary resignation point. I do agree that Judge Walker did seem to stress the word voluntarily, but that doesn't matter. The point is that the sale to Deluxe of some of the assets did not cause Mr. Weil to lose his employment with Western New York IT. In fact, in addition to the 4 people who stayed at Western New York IT working in the data center, we also had Christopher Fabozzi, who put an affidavit in, who worked for a period of time with Mr. Weil post-sale at Western New York IT at Velocity. And then at some point, both Mr. Fabozzi and Mr. Weil decided the grass might be greener on the other side and took a different job. There is nothing in the record to suggest that Western New York IT had no work for
But there's a
him.
question, though, because how was he going to get paid? He
Western
was
New York-
paid, he was paid primarily based on the annual bonus, which was 10% of the net profits, and those had left.
Well, not necessarily.
Velocity was sold $24 million worth of its assets.
Correct.
And their net sales were still going to be able to compensate Weil at $300,000 a year?
Well, they weren't $300,000 a year every year, Judge. They
Right.
were $11,000.
But that was the
one year.
point. This whole agreement was designed to keep him there so that he could help build this company. This was a golden parachute. And then when the company sold for $24 million,
Respectfully-
he no longer, so your position is if he was offered a job as a janitor, if they changed his responsibilities to just be the janitor, he wouldn't have triggered the contract?
No, Judge. Respectfully, I disagree as to the formation of the retention bonus. The retention bonus, as the record demonstrates, came into existence because Alex Weil wished to change his phantom stock agreement, which he had at the outset of his employment with Western New York IT, to this retention bonus agreement. This was not designed to be a golden parachute.
He wanted ownership. He explained during his deposition, he felt he was a key member of this firm. I think he wrote the software himself, wrote the code. He wanted ownership, and this was meant to appease him and keep him from walking, is the way he described it.
Well, as a matter of the calendar, that's not credible because the retention bonus agreement was entered into 3 years before even the contemplation of the sale ever happened. So Mr. Weil began working for Western New York IT in 2012. At that point, he had a phantom stock agreement. At a certain point in time, he decided he would do better if he could change and get a percentage of the profits, of the net profits every year. So as the record demonstrates and in the
And the percentage of a sale if it ultimately occurred.
That, Your Honor, respectfully, was almost an add-on.
Right,
The
it
point was the annual retention bonus
Right,
year
but
after year.
it was in there, that sale provision was in there.
Correct, it was. And it was set up explicitly with 4 conditions. 2 of them undisputably were not met.
Which ones?
The one where he was prohibited from taking any stock directly or indirectly in the
Didn't that
purchaser.
occur after the sale? Like it didn't occur simultaneously, it was something he got later on. Was that not true?
It was within the year, but yes, it was not at the time of the sale. That is
Well, wait, correct. The sale was in 2018. He didn't get the stock till 2019.
Correct. That is
Next
correct.
calendar year.
That is correct.
So he's prohibited from any, let's say he stays with Deluxe and they have stock, he's prohibited from getting a single share like everybody else. And if he takes one share, then he forfeits the large sum of money he would otherwise be entitled to?
Well, that's not the sole purpose, that's not why he forfeited his bonus. He forfeited his bonus when he decided on his own that he would do better
Okay,
going
right.
with the new company.
That's the real issue, I think. I'm not sure the stock issue is your best one, but we'll take a look at it. Right, so your argument is that he voluntarily left. He could have stayed with Velocity. Because he chose to go with Deluxe, he loses millions of dollars.
Well, he made a decision, Judge. And in the record, the data center where everybody worked, with the people that stayed behind, was never sold. It was an excluded asset. The data center is what Velocity Western New York IT is. That is what it is. It is true that one of the products that came out of Western New York IT, my client, is this portal that Mr. Weil was an integral part of. I will also note, and I don't think it's lost on any of the judges here, that within a year, maybe 13 months of Mr. Weil leaving, Deluxe fired him. So I don't know how important he was to maintaining that portal or whatever. As we put in the record, there were many deficiencies in his performance that carried over to Deluxe. Now,
Can I ask you this, though? Let's say there were evidence that Velocity said to him, we're selling the business, we're going to maintain this data center. There's no job for you there. I've got my family here, we're set. Love to have you, but there's no room for you here at our new business.
Yes, Judge, those are very different facts.
So, right, so then your client would lose under those facts?
Yes.
Gotcha, okay. So,
Which
because
is-
we don't have those, right, but
Correct.
Mr. Weil does say the position that I performed for Velocity and then for Deluxe, they didn't have those, they didn't have a need for my services at the spinoff of, with respect to the data center.
Respectfully, Judge, what Mr. Weil doesn't say is more important. If you look at the statement of undisputed facts submitted by the plaintiff, it does not say that he lost his job because of the sale. It says, and it's very carefully worded, and Mr. Joyce is, my friend, he's an excellent lawyer, he's very careful. It's a very carefully worded statement of facts. It says there was a sale, and then the next paragraph it says, after the sale, Mr. Weil became employed by Deluxe. It does not say the sale caused that employment to end.
What about his argument that the APA required, it prohibited Weil from working for Velocity?
Well, we put that in our brief. It most certainly did not. What that provision does is it prevents us from poaching employees that leave on their own and work there and come back. So we are, it's a funny position, but because he voluntarily left and because he took that job, not because he had to, because he left, we're prohibited from going back and trying to poach him and steal him back. So he left, he could go, we let him go.
Was there any offer for him to stay with Velocity? Formal job offer? With the new company?
Respectfully, there's nothing in the record, but if you're inviting me to go beyond the record, I can tell you that we would have loved to keep him, that Jonathan Bilo and...
I thought you said that his performance was really shoddy, he didn't come to the office a lot, and you just, like 5 minutes ago, were telling me what a bad job he did.
Well, that's right. He was deficient in terms of his actual performance in connection with the portal, but the portal's gone. The portal is not our problem anymore. We were looking for other projects, and the data center, as we have in the brief, continued to exist. We continue to have other customers, to the date, continue to have other customers. It's a viable entity with other employees and other accounts that are not Deluxe, and he could have been a part of it. Now, do we begrudge him the fact that he thought he could do better at a new company, at a growing company with, further development of the portal? No, that was his choice. He took a bet on himself that he would make more money at Deluxe than he would have in getting an annual retention bonus going forward. The annual retention bonus isn't tied to the portal. It's tied to the net profits of the company. And there's nothing in the record to suggest that the net profits of the company wouldn't continue to pay Mr. Weil. And by the way, hindsight being 2020, he would have made more money even if it was $40,000 a year because Deluxe fired him.
Right, your view, to wrap it up, is that if he wanted 10% of the net proceeds of a sale, there shouldn't have been any provision about this if you lose your job as a result thereof. It just should have said, I get 10% of the net proceeds,
That's right.
regardless of where I work. But that's not what it said.
Words matter. That language matters. That provision that says because of the sale means something. And had that language not been there, he'd be in a different position. And by the way, this argument that he had to go because they would have had nothing to pay him is counterbalanced by the fact that had he stayed, he would have had that bonus. And even had he stayed with Velocity, had he not voluntarily given up his job and gone to Deluxe.
So the sales didn't follow the buyout? I mean, it was the net sales was how he was being paid.
The net sales
didn't follow the assets?
Velocity, no. Velocity is still in business. Velocity still has the data center.
That the net sales were not going to stay with Velocity because it had all left.
That's his speculation that was contradicted by Linda Clark and John Bilo and Chris Bobosi.
And that's a question of fact, though, isn't it?
On whether his...
Whether his job still existed. I mean, a job requires getting paid for your work.
It is a dispute about the facts, but it is not a controlling question of fact in this case because the agreement says you only qualify for the bonus if your employment is terminated because of the sale. And the sale may be in the chain of events, approximate cause, one of the factors that caused him to leave. But the reason he left is he thought he would make more money at Deluxe than he would staying with us. Had he stayed with us, in hindsight, he would have had the sale bonus, which he forfeited by leaving, and even if he was only making $40,000 a year, he would have been better off. He bettered himself and he lost. And
That's why Judge Walker mentioned voluntary in his decision. That's what he was referring to, that part.
That's right, Judge. And even though voluntary is not in the word, that's the controlling. And I would return your attention back to the statement of undisputed facts. We put in facts in Bilo's affidavit, in Clark's affidavit, in Bosey's affidavit. He voluntarily left. He could have stayed. He left on his own. And in Mr. Vile's statement of facts, he suggests that there would have been no work for him, but he never says that we said that. And his statement of undisputed facts never says that. He never says, I lost my job because of the sale. He didn't produce any paper to that effect because there was none. It would have been nice if we would have had something in writing that would have said, oh, please, we beg you to stay. But, he made his decision, and that's the way it went.
Thank you, Counsel.
Thank you. See you on Friday. The latest.